Okay, it is 8:30 p.m. and it is Tuesday, and it is February the 25th, 2020, and welcome to week 3 of Introduction to Criminal Law. I'm Professor Richard Wright. Everybody should be aware of the fact that week 3 signals the halfway mark, and that one of the things that you'll discover, and I've been saying this all along, that you will be completing your first quiz, which will be for midterm, and that will be due on Sunday. We'll go over that in a few minutes. So right now I'm going to go ahead and share my screen. Get started here. Okay. You can see by looking at the schedule here that we're at week 3, and then we'll have 3 more lectures after this. The link for lectures 1 and 2 are in here, and then I will put the same thing for today's lecture. So now let's take a look at the announcements. So in this week, last week it was crimes against property. This week we're going to deal with crimes against persons. And I previously sent you the PowerPoints for chapters 4, 5, and 6 of the textbook, A Brief Introduction to Criminal Law. And we're going to go over the sections: homicide, battery, domestic violence, sexual assault crimes, and then we're going to deal with some key terms for practice, special circumstances, homicide, classifications, and then finally that practice quiz, which I encourage you to take. As I indicated, each week there is a practice quiz. I do recommend you look at those again to get ready for week 3's quiz, which is coming up. Your initial post: what type of homicide is this? Is due tonight at 11:59 p.m. Central Standard. Your reply post: Saturday, 11:59 p.m. Central Standard. And I do encourage you to reply to more than one post. And also I remind you that your post should contain information that indicate that you thought about your answer, maybe did some research, and provide details in your initial post as well as your reply post. Finally, complete the written assignment: spousal rape, and then, of course, the quiz, as I talked about, which will be timed, and those will be due this Sunday, and that will be March 1st. Then you know what my motto is all about. Okay, let's take a look at the course calendar. Remind you again. Okay, here we are. We're at the 25th, and again, we're completing week 3. Your initial reading assignment again, given what I just gave you. Your initial post: what type of homicide is this? And of course your live lecture. You click on that, it tells you even the link. Then your reply post: Saturday. And then Sunday, you have your timed quiz, as well as your, let's say that again. There's a quiz. Thought I had in here written assignment. Let's see. Okay. I got it in here twice. Okay, so your written assignment is due also for the 1st. And the written assignment is what I just gave you a few minutes ago. I'll have to correct that. Give me a second. Had it in there. Yeah, that's right. I thought it was spousal rape. So let's go back to the course calendar again. Make sure I correct that. Put that in there. Okay. All right. There we go. Okay, so now we have the quiz and the written assignment. Spousal rape. All right. So those are the assignments, and then you can see that by Sunday when you turn in your assignments, we will be in March, so that next week at this time will be the 2nd. So we'll have 3 more lectures to go. And the class again ends on the 20th. I always remind you guys, it's the last day. The 20th of March is the last day of class. All right, let's put your course tools and close that. And let's go right to the module itself. Again, let's elaborate on the assignments, your discussion, what type of homicide is this, and you're going to use this fact pattern, and then you're going to address this in your initial post as if you were the investigating officer to determine what criminal charges you recommend against James, first-degree murder, involuntary manslaughter, or voluntary manslaughter, and explain in your initial post which criminal law is most applicable to this case and why the others are not. Your reply post, examine a student who has something the opposite of yours and do the same thing again with the reply post. I remind you to help with assignments. We have the guides to help you with criminal justice, criminal law class. Again, if you click on this, it takes you to the guide that's specifically designed for this class. There's one for this class, then there's one for drugs and crime. Okay, those are the 2 classes that I teach as well. Then there are other courses as well. And if you look at, it talks about setting up the discussion posts, and it helps you with your written assignments as well. Make sure you utilize the resources that are there. So now let's look at spousal rape. This is a 2-part written assignment. You must do both parts. Please separate the parts so I'll know which is which, so that in the first part you're going to examine the type of crimes that are committed. Now, this is a short paper addressing these issues. Remember rubric, remember citations and references and cover sheet, double space. And this is a scenario. Address the following in a minimum of 2 pages, not counting the reference page. So a minimum of 2 pages for the first part, okay? To complete this assignment, make sure you deal with each of these 3 aspects. And make sure that you cite your sources. Try to minimize, and I say this over and over, minimize using your textbook. Don't use your textbook as a primary source. So the key thing is for us to make sure that you are conducting research in your written papers. Again, reminder, APA, citations in the body, and references at the end, properly formatted. And then the second part, you're going to conduct an interview. And in this part, you'll consider the types of interview questions you would ask a victim to determine which criminal law has been violated. Double space. Double space. Should be a minimum of 1 page. Double space. All right? And if you get your questions from a source, make sure you cite the sources of those. You only have to have 1 reference page for both assignments. Cite your sources in the second part if you use some. Most of you will. And then again, this reminds you of the guides, and it tells you how to help you with your assignments, library, APA toolkit, and tutoring and writing lab if you need any. Submit your assignments by Word document. Do not submit your documents PDF or any other form. It must be Word documents, all right? And I will have to be able to put them in Grammarly. Remember, I run all your papers through Grammarly to determine. And do not use sources that are not credible, such as Wikipedia, other sources. Don't use paper mills like Course Hero or other of those type, because I will pick those up and when I do the Grammarly check. So let's look at the rubric. Remind you of the due date that I've already shared. For 40 possible points, you must satisfy each of these. List the elements of offense and explain how they have been met. Explain the type of crimes committed and why the initial responding officer mishandled the case the first time. So 2 pages. Remember that. Double spaced. APA formatted. And then the second, conduct the interview of how you would approach the interview of the victim. Identify questions that must be asked when investigating these sensitive crimes. Again, if you take some of your questions from sources, cite the sources, and make sure you include it on the reference page. And then make sure you're in paragraph form, double space. And then finally, this is the standard format for APA with a title page properly set up, a reference page, proper spacing, paragraphs. All your papers should be in paragraph form, double space, not single, with in-text citations in the body of the paper, not just a in-text citation. And as I said earlier, try to minimize using your textbook as a source. There's enough sources that you can find in the Library and Learning Resource Center that we provide, and you can find some more information about that in that guide that I told you for this class. All right. So that's the written assignment. And then finally, you have your quiz. It's set for 30 minutes. You'll have 1 opportunity to complete this quiz. You're not supposed to have any notes or papers or anything out. You're not supposed to be looking up answers. And you need to make sure that you complete these quizzes in a timely fashion. Once you start the exam, it's going to continue and it's going to, until the time run out, for the 30 minutes, you're going to find that the grade's going to automatically be submitted. Okay, and then of course your live classroom lecture will also be due March 1st as well. Going back to the quiz, same thing, March 1st, 11:59 p.m. Central Standard Time. And those are the assignments for this week. If you have any questions about the assignments, please type them in the chat box, and I'll address them during this session. And if you do type something, type it public, don't type it private, so that everybody will have the benefit of it. Okay, so now let's go into the actual lecture. So you're going to discover today that as we talk about crimes against persons, that you're going to see there's more severe consequences for crimes against persons. Last week, as we did crimes against property, and the theory is that you can replace property, but you can't replace life. And so, as a result, the sentences are more severe than against individuals who commit crimes against property. And then we deal with the issue of felonies and misdemeanors, which we're going to differentiate and talk about that in a few minutes. And so we're going to get right into it. So we're going to deal with the homicide, the battery, domestic violence, key sexual crimes, and then we're going to close out by dealing with the things to help you to get ready for your quiz. I already told you about the discussion, the written assignment, the quiz, and the live lecture. All right. So what is homicide? Homicide is very simply killing of another person, or as it says here, the killing of a person by another individual is homicide. And there could be lawful homicide, and there could be unlawful homicide. And so, for example, it says when a police officer uses deadly force to prevent great bodily harm to themselves or others, this is homicide, but it's justifiable homicide. So just because you commit a homicide doesn't mean that you go to jail or charged with a crime. But police also must make sure that the deadly force they use are commensurate with the situation and circumstances in which they utilize it. For example, if a person raised their hands to a police officer to strike them, unless they're like a karate expert or somebody like that, then they're not using anything that could result in deadly force. But if they have something in their hand, let's say they have a hanger in their hand, and a police officer shoots them, that would be excessive force, because the item that the individual possesses would not necessarily represent the need for a deadly force. Remember, the only time deadly force is used is to prevent great bodily harm or death to themselves or to others. All right, and the police also must find themselves in situations where it was necessary to take the life of an individual. We don't deal with this shoot to maim thing. There's no such thing. People thought that you can find yourself in being charged with excessive force if you shoot to maim someone. Also, there are times when individuals are fleeing unless they represent a threat to others. Then in that case, deadly force can be used. There was an argument in the famous case here in Chicago called the Laquan McDonald case, where a police officer shot a young kid 16 times, and it was clear from the video that was made public and was utilized in the court case that the individual had a little knife, not even a big knife, and that he was at a distance far enough away from the officer. But there were other officers on the scene, and this one officer got there and took out his gun and shot 16 times. Now remember, to shoot somebody 16 times, you have to do something other than one round. It's more than one round. And so the videos demonstrated that this individual was shot in a unjustifiable fashion, and as a result, the police officer who did this was charged with attempted murder, aggravated battery with a firearm, and other criminal charges, and is currently serving time in prison for that. So, again, all circumstances must be justifiable. When a person is upset, as it talks about, and intentionally kills a girlfriend because they believe they cheated, then the killing is unlawful and is referred to as murder in those kind of situations where you commit crime, where the excessive force was unnecessary. But then there's some jurisdictions that we deal with when we start talking about voluntary and involuntary manslaughter. And we're going to talk about each of these right now when we deal with the homicides. We're going to deal with primarily the three. We're going to touch on special circumstances. So what is first-degree murder? It's what commonly is referred to as murder in many jurisdictions. So there are some elements that are necessary in the homicide to elevate the crime to murder. And it talks about it right here. It says there must be premeditation. In other words, some planning, some thought about it. You didn't just do it spontaneously, but you gave it some thought. And then the second part was the intent to kill the person. Now, as it says here, that forethought and intent is commonly proven by the actions or statements made by the defendant. So let's say, for example, if a defendant says, "I'm going to kill you," and then they take out a gun and they shoot you and kill you. Or if they take out a weapon, a bat or something, and says, "I'm going to kill you," and then they kill that person. That would be deemed murder because of the fact that it would be deemed that they either thought about it, planned it, and then they intended, and therefore the forethought and intent is proven by the statement of the individuals that come out of their own mouth. And we're going to talk about a couple of those examples. So the state of Minnesota has it commonly laid out the way it is in most jurisdictions. Causing death of a person by premeditation and intent to kill. Remember those elements. The death, of course, remember we said homicide involves death, and it has to be a human being, okay? Premeditation and intent to kill that person. So you must have thought about it and then did it. And anything that involves actions that result in planning could result in first-degree murder. So it gives some examples here. that intent demonstrated if it was later determined that the killer had told someone of their intent to kill a victim, and in fact did do that, then the statement could be used to support intent. Just what I said a few minutes ago. Sometimes the intent is more obvious, though. For example, if a person witnessed screaming, "You're going to die, you're going to die," and then fires the gun at the victim, again, it's clear that the act was intentional versus an accidental discharge of a firearm or weapon that caused the death. Remember, again, the statement can imply intent. Evidence of motive could also be uncovered to show that the person had intended to kill the victim. For example, previous email, texting, indicating that the person was in the process of giving thought to it. Or we use that as planning or premeditation. Premeditation, that means before the action. Pre is before, and then meditation. And so the action, and what you do is you indicate clearly in this information that you're going to kill that person. And let's say, for example, if a person, as it talked about killing for insurance money, same kind of thing. That's a malice and a forethought. That means you planned it. You thought about it. You gave it some idea. You did it clearly for an illegal purpose, and it would support a first-degree murder case. So you're going to discover scenarios, which we're going to have a few tonight we're going to take a look at, but you'll run across them in your exam that will present, but remember the element that you're going to have to look out for: premeditation and intent. Premeditation and intent of killing a person. If it's an animal, it's not going to be murder because it has to be a human being. Okay? So that's first-degree murder. Now let's look at what some people refer to second-degree murder, and in some jurisdictions, the term involuntary manslaughter or voluntary manslaughter is included. So this is when we get to what we call the lesser included offense, when there's no premeditation or it can't be proven. Then in criminal cases, usually juries are told that second-degree murder would be something like what I'm about to say. The person who is charged with the crime and knowingly, listen to me, knowingly caused the death of another person. Now, the element of second-degree murder does not require, I repeat, no premeditation. So if there's no premeditation involved, or the mindset of the person at the time of the act, but they include the intentional killing of a human being of another, then we're talking about that. Here's how you can really protect yourself in terms of knowing which one is which. If it's done in a fashion where a person is killed by a person, but they do it out of passion. They do it out of a quick response, but not necessary. You can, for example, have excessive force in cases where a person is found guilty of second-degree murder. As I was talking about that young man who was killed, there was arguments made that the individual who was killed with the 16 shots should have been first-degree murder, but second-degree murder because it was argued that at the time the person was a police officer and maybe their adrenaline was flowing, and so they fired all those shots. Of course, it's all in the eye of what the prosecutor decides to charge the individual with, and or what the trier of fact, in this case the jury, would find an individual guilty of committing. So voluntary manslaughter is another form of second-degree murder. When the killing is done without any prior intent, but occurs in the heat of passion, like I said a few minutes ago. A heat of passion takes place when a person of ordinary experience lose control and they kill a human being. Heat of passion type cases occur, like, for example, if you walk up on someone such as your spouse or your significant other having sex with another individual, and you take out a weapon and you kill them both. Then in that case, it could be second-degree murder. But if you see them and then you leave and then you go, and some time lapses between that period, and then you come back and do it, it's going to be premeditation and planning, and it's going to be not voluntary manslaughter, not second degree, but we're back at first degree again. Heat of passion killings are applied in murder cases when the murder happens immediately in the moment. That's the point I'm bringing to you. And that's the key. That's the key. If any time lapses, the closer you get to murder in itself. I had a young lady that I knew pretty well, and she was the victim of domestic violence at the hands of her husband. And he was pretty violent. And he would, just beat her profusely. Well, one day, she waited for him to go to sleep, and then she got a gun, and she shot and committed homicide against that individual. Do you think she was guilty of first-degree murder or second-degree murder? Or voluntary manslaughter, which is the same? Which one you guys think that she was probably charged with and found guilty of? Adam says first degree. Anybody else? Okay. And the answer is correct because of what I said earlier. So it makes it pretty clear that that's how you determine it based upon that. And but you know what though, and I'll talk about that a little bit when we get to domestic violence a little more with her case. But the point of the matter is that all of the elements were present to find her guilty of murder. Now, look at what it talks about. It talks about it would be difficult to lessen the severity of a murder under the concept. And this concept, if Bob came home to find his wife in bed with Jim, but then hunted Jim down the next day, then in that case, just like what I said a few minutes ago, time had lapsed. But it has to be like, bam. Here's the deal, people. It has to be that that person was so incited. And then, now, let me ask this question. Let's say you talk to your spouse or significant other, and then they tell you, you ask them what they're doing, and then they're stupid, okay? And you'll know why I say that when I get ready to give you this hypothetical. And they say to their significant other or spouse, I'm at home in the bed with Jim. And the person comes home and kills both of them. What do you think? First degree or second degree? Okay. And the answer to it is correct for all three of you. Both of you said first, and I could see the case for first degree murder. But I could see a good defense lawyer painting the picture that at the time he was told this, that his crime of passion, his stage for the crime of passion was so incensed that he came upon it, and when he saw it, then he did it. So it could go either way. So that's a good one. That's a good one. But the elements of time passing is what made you guys say first degree murder. And like I said again, I could see this going either way in a situation. I believe that during my years of lawyering, that I could probably argue a case for second degree murder because of the fact that he just went. You just go. Somebody tells you that. It's like you just lose who you really are. Okay? Now, I'm not talking about some time passes, but I'm talking about you come home and then you see it. You know. So now, if it could be argued that you talked to the person and you went and bought a gun, then you'd be leaning more towards what Chris and Adam said, and that's first degree, because once again, then you're intervening. But let's say you had the weapon, or you came home and you discovered it, and then you took your weapon out that you had then in that case, but you didn't go buy a weapon specifically to take the life of those individuals. So that's an interesting situation, and that could fit in the next area that we're gonna. But just keep in mind that it's voluntary manslaughter, not involuntary. We're going to talk about the differences in the two. And in many jurisdictions, and I said this before to many of my students, that second degree murder is also called voluntary manslaughter because it was an incident where the death of the person took place, but there was no premeditation. Okay, that the person just kind of lost it and then resulted in killing the person. So 9 times out of 10, you're going to have a good second degree murder case there. So let's talk about little special circumstances for just a few minutes. Special circumstances is when there are intervening factors that may lessen or increase the severity of events. And it kind of fit in what I just talked about a few minutes ago. All right, so let's say first degree homicide, special circumstances. Now here are some circumstances that make it more aggravating and leaning more toward homicide in the first degree. And these are usually what we call our death penalty cases, except in jurisdictions where there's no death penalty. Illinois, Wisconsin, to mention the two, don't have death penalty. We did away with the death penalty here in Illinois 2000, and I think it was 13. Yeah, I think it was 2013. My former classmate at Northwestern University School of Law, and the person that I mentored, because he was 2 years behind me in law school, was Governor Pat Quinn of Illinois. He signed a one-liner doing away with the death penalty. It was already under moratorium for other reasons from a previous governor. But anyway, the point of the matter is that we don't have, and we have not had the death penalty in our jurisdiction since that time. So anyway, in these aggravating factors, for example, Missouri, state of Virginia states that aggravating factors relating to the death penalty are future dangerousness, the probability that defendant would commit crimes or violence that would be a pattern or a serial type thing, or a threat to society, or violence, that the conduct was outrageously or wanton, vile, horrible, or inhumane, and include torture, depravity of mind of an aggravated battery to the individual. Now, if neither of the aggravating factors are present in the way Virginia has it, then the defendant is sentenced to life and not death. So that's the way it is. Now, unless, again, the individual fits the mode where under the statute that individual, maybe because of their age, they could not be sentenced to death. I'll give you an example. This was back when we still had the death penalty in Illinois. I represented a young man who committed a very heinous act. He raped the young girl who was a meter maid, who came to the house to cut on the utility, not to turn it off. And it was just him and her. And then he, according to his statement, lost control when she bent over, and he took advantage of her with a weapon and sexually assaulted her, and then stabbed her multiple times, tied her up, and then rolled her body in a garbage can down the street. Well, I became his lawyer, and immediately one of the things I did after I did all my motions and everything was work out a deal to keep him from going to the penitentiary for the rest of his life. Now, this fit the crime where he would qualify for the death penalty, except one reason he did not was because at the time he committed the offense, he was 17. And in Illinois, this was before Roper versus Simons, which stands for the proposition that we don't execute juveniles for any crime. So therefore, the states were split, and in Roper versus Simon, excuse me, which I'm pulling up for you here. Okay. Here we go. It is if you want to go look at it yourself, it is 543 U.S. 551, a 2005 case. So that was long after, because I retired in 2000. This case was in the 90s. So anyway, Roper versus Simmons, the landmark decision by a 5-4 decision, held that it is unconstitutional to impose capital punishment for crimes committed while under the age of 18. And so since that time, that's been the law of the land in the United States. But at the time of the sentence, he was 18 years old. So anyway, he had the satisfactory issues. But Illinois was a state at that time that decided before Roper that they would not execute juveniles. So he ended up serving natural life, and that's where he is right now. So anyway, so you can see how a person, this is an aggravating factor, a special circumstance for a first degree case. Now let's look at second degree instead. Second degree has one element of the crime that distinguishes it from first degree. First, there is an intent to commit the homicide, okay? That's in both cases. But the difference is that in the second degree murder, it is knowingly and not premeditated. Now, by the way, the premeditation aspects of it also applied in this case with this young man. under special circumstances because he tried to hide the body. He also tried to hide the evidence and all of that. So that was some planning that took place as a result of that. And so anyway, the difference is an element for second-degree murder has less malicious intent and relies on the circumstances that take place at the time of the offense. So you deal with the aspects of adequate provocation, which occurs, they say, that that may deprive a reasonable person of self-control. They lost control. Someone said maybe that's the case with this kid. But here's the problem. Bob comes home and finds Jim in bed with his wife. Enraged, Bob shoots and kills Jim. Bob would likely argue adequate provocation because he had lost control and the possibility of second-degree murder. Remember what second-degree murder is also called. What else is second-degree murder called? Remember, I told you. What is it? Yes, exactly. And so that would be in many states, including my own here in Illinois. Now, the coercion necessity, that's because the person was forced to cause it. For example, Jack is taken hostage, and the hostage taker has a gun to his head. The hostage taker tells Jack, "Shoot Bob, or I will kill you myself." Under those circumstances, he shoots Bob. Well, he was forced, and so it's second-degree murder under special circumstances. And probably in that kind of a situation, he would probably not be found guilty by anybody in any stretch of the imagination. Statutory examples of Wisconsin and Florida highlight how adequate and provocation and coercion created. So I'm going to get into the fact that much deeper, but some affirmative defenses acknowledge that the crime was committed, but some offer an excuse to negate the culpability, and that's found in your textbook. You'll find that information. But the burden that as an affirmative defense or adequate provocation rests with the defendant. And, so we'll deal with affirmative defenses later, not today. And then in Florida, it referenced with a depraved mind when the murder happens in the heat of passion. That is adequate provocation, which could create a second-degree murder situation. Okay, so don't worry too much about special circumstances. You might run across some. We're going to have some practices with just a few of them tonight. Involuntary manslaughter. Okay, now, this is what we usually refer to as manslaughter. That's the way. When a person kills another, but there is absolutely no premeditation or malice, but reckless actions cause the death. Like, for example, driving under the influence of alcohol causing the death of a person. And it talks about that in an involuntary manslaughter situation. But the levels can also be argued based upon what we call utter disregard. And utter disregard for human life is when a course of action demonstrates and shows actual deliberate intention to harm, of which, if not intentional, shows an utter indifference. In other words, speeding in an area where just to show off to somebody. You'll see that example given in a few minutes. In contrast, reckless means the indifferent or carelessness of the welfare. Both of those, again, can result in involuntary manslaughters. So what degree of involuntary manslaughter, as we conclude this section here, And here's a case, simple fact pattern. This is kind of like what I was talking about a few minutes ago. 11:30 p.m. on a clear but cold January day. Streets are dry. Jim, who's intoxicated, operates his vehicle in a speed zone in residential for 25-mile speed limit. That's the speed limit posted. And so his girlfriend is seated next to him. They both drunk. Okay, he just wants to impress her and hits the accelerator to 80 miles per hour and drives through a stop sign and collides with a vehicle and kills the individual. Did Jim demonstrate utter disregard for human life, or were his actions merely reckless? Which one? Disregard for human life or reckless? Which one? Everybody says reckless. Actually, it was not. Remember, utter disregard for human life is defined an action which shows actual or deliberate intention to harm, which, if not intentional, shows an utter indifference to or conscious disregard of the person's own safety. You guys would probably argue that because he was drunk, that's why you don't say utter disregard. In contrast, reckless simply means indifference. However, they can be muddied. They can be muddied. I could see it going either way in that scenario as well, because we don't allow voluntary intoxication to be utilized as a basis for not having a person held responsible for their actions. So that's a either way. So you might be right. You might be right, and it can be argued. Only part about it is that when you're taking these tests, you're going to have to think like the person who wrote the test and give the answers. They try not to trick you in these kind of situations here, okay? A one-punch homicide, and then we're going to conclude this. Involuntary manslaughter can occur in the context of battery cases. And we're going to talk about battery in another lecture. But the term one-punch homicide used to describe instances when a person intentionally batters, that is, punches another, but the one punches result in that person's death. So it depends on the kind of punch that individual, and it also depends on who that individual is. Say it's a boxer, then we get into the one punch homicide. So I'm not going to get into these clips. You're not going to run across those, though. My recollection last time I looked at the quiz is that we didn't really have any of this, but stay on the lookout. Now, all right, so that's it with homicide. All right, remember, now we're going to talk about crimes that don't involve a person dying. All right, so now we're going to talk about battery. Now, battery is very easily defined in the common elements: intentionally injuring a person without consent. Intentionally injuring a person without consent. For example, we get into simple battery, which is a misdemeanor. And how do we know if a crime is a misdemeanor? Do any of you guys know if a crime is a misdemeanor? How do we know if it's a misdemeanor or not? Does anybody know? How do you know if a crime is going to be a misdemeanor? You probably will be silent on this one. It's the sentence. The sentence. If the sentence for the crime that is committed is less than a year, it is a battery. Well, you say severity. Yes, but that's why the crime of simple battery is a misdemeanor, because it's not a very severe offense. And so as a result, it is classified as a misdemeanor. So you're going to see in a minute what I was talking about. Yeah, a year, let me see. Let me go down here. I want to see. I think she got this right. Carol. Battery is less than 1 year. Battery is less than 1 year. Simple battery misdemeanor. Yeah, simple battery is just generally battery in itself. But yeah, it is. Your sentence is less than a year. And usually with a battery, do you go to jail or do you go to prison? Those of you who took Introduction to Corrections should know the answer to this one. Yes, yes, it is. It is absolutely correct. And so the battery is classified for its severity. It's a misdemeanor typically charged when one intends to batter another and cause a minor injury. In contrast with a substantial battery, which is a felony and sometimes referred to as aggravated assault, and involves a weapon or some item that can create, like a bat or a knife or something like that, okay? Don't get caught up in some states battery may be considered as assault. I want to tell you up front, forget that statement. This is how I want you to remember it. Assault. Here is assault. Now, if I raise my hand to you and place you in fear of being struck, then that is assault. A reasonable belief that someone may harm someone. All right? Now, if someone pulls a gun on you, that's going to be aggravated assault because of the fact that you're now using a weapon. But let's just stick with assault, because you usually hear the term assault and battery. I explain to people that it's very easy to commit a battery and assault, but the assault is the preliminary to the battery. So assault creates a reasonable belief that if someone is going to be harmed and involves no physical contact, that's why it can't be used as battery. In some jurisdictions, it gets confusing. All right? No physical contact, and the defendant and victim, unless the assault is defined otherwise by a statute, like it was up here in Utah. Okay, statutes can change it, but at common law, generally, the application on a wide scale and in most jurisdictions would be where there's fear of being struck. But the actual battery itself is when someone strikes someone against their will and involves actual physical contact, okay? All right, I'm going to have to move on because we got more stuff to cover, and it's 9:29 already. So you look at bodily harm, but I've given you the basis for this. You can take a look at this. Mayhem, you won't run across that a whole lot, is when a person maliciously deprives a person of a member of their body, of a part of their body, or disfigures their body, something along those lines. Okay, and you can see that scenario there. Domestic violence. Domestic violence is very simply violence that takes place when a person is in some form of relationship, living together, or either have a child together, one or the other. And it's a crime that occurs quite frequently. As you heard my story, I was the victim of seeing domestic violence in my home on a regular basis coming up as a child. And I have taught the course on domestic violence. And it is a crime where it can affect people a great deal. It took me and led me to becoming who I am today. Very few people go the route that I did. Some go the other route that results in them becoming domestic abusers. In most states, a domestic relationship exists, such as battery occurs between the two adults at least 18 years of age who have lived together, been intimate partners, or have a child in common. And that's pretty much the standard. Okay, and that's all I'm going to say about this. Two adults who live together or have a child in common. All right, keep moving. Sexual assault crimes. Sexual assault crimes are generally classified as individuals who were raped, but it's called more sexual assault now. The actual intercourse, a male with a female other than their wife without their consent. But it is more referred to now as sexual assault. It's the same thing. It doesn't require that the intercourse take place, but also includes unlawful touching, however slight, of a private area of an individual. Okay? Sexual assault, and then they get in here and they describe the various degrees of that. Okay, I'm not going to go into all those various ones. Now I'm going to talk about statutory rape. Statutory rape laws are what we call strict liability laws. And intercourse between a juvenile person under the age of 18 and varies from state to state. One constant is that the minimum age of consent to engage in sexual activity is between 16 and 18 years old, okay, and depends on the jurisdictions themselves. It is considered a strict liability laws, which simply means this: you cannot defend by saying, I didn't know. The person looked older. The person carried themselves older. The person had phony ID. Not going to do it. When it says strict liability laws, it didn't require a showing of intent, and the mere engaging of the act itself with a person who cannot legally consent, and that is their age, in of itself makes it unlawful. It's never a defense to a minor consented, because minors can't consent, period. That's it. All right. So now let's get into preparing for the end of this week, and let's go through and spend some time now before I let you go and give you the key phrase, some key terms. So let's see how you guys pick up what we talked about today. I'm going to ask you for answers, and you type them in the chat box. So here we start off with a special circumstance where death was caused because the actor was forced, not by their own creation, to cause it under the belief that they were compelled to. What is that special circumstance? What does it result in? Somebody typed it in. It was real quick. Let me go back and pull that chat up. Coercion. Wait a minute. I did that wrong. I went to flip card. Go back. Where the death was caused. Okay. Exactly. That's exactly right. coercion, necessity. Next one. The intentional causing of death of one human being by another without premeditation, forethought, or planning. What do we call that? Murder, manslaughter. What do we call it? Okay. How about this? Second-degree murder. Remember? It's the same thing, but remember what we call it in this course. It's second-degree murder. Remember we talked about that a few minutes ago, but you were kind of on to it. It wasn't murder, but it was second-degree murder. Penetration into the vulva, penis, or anus, or any part of the body, including cunnilingus, fellatio of, what do we call that? What do you think? People have a tendency to want to say rape, but it's just sexual penetration. Oops, let's go back. The unlawful malicious depravity upon the body of a human being that results in disabling, disfiguring, or renders useless, or cuts or disables the tongue or an eyelash. What do we call that? We went over it real quick. Starts with an M. Anybody remember? Remember this? Mayhem. Anybody remember this? I went over it real quick, but it's mayhem. Physical pain or injury, illness of any impairment of physical condition. What is it? Everybody's getting quiet. Oh, somebody did have mayhem. Okay. Bodily harm. That's all it is. And then the last one. Laws that don't require a showing of intent and the mere act of engaging in sexual conduct intercourse with a person who cannot legally consent is called what? Anybody? That's the kind of crime it is, but that's not the crime. That means no defense to it if you committed the offense. But what is it? But it is. It's law. If you want to call it that, you can all be right, but it is a strict liability law. But the way they write these questions, sometimes you have to really, laws that require a showing of intent and the mere act of engaging. So I guess technically you're right. You were right, Chris. It was. And then statutory rape is exactly the broad aspects of it. So you all were right. When one person kills another, but there is no premeditation or malice, evil intent, but reckless actions cause the death. What do we have there? involuntary manslaughter. So you go through these, and you want to make sure that you go through them. Very, very important. Okay, let's go down. Okay, special circumstances. Let's do maybe a couple of those, because you might run across one. I think is on the test. I know at least. Okay, let's look at this. Jane and Phil have been married for 10 years and have 2 children together. Jane also has a drinking problem. Jane came home drunk and argued with Phil. Phil threatened to leave Jane and take the children if she didn't get help. Enraged, Jane shot Phil and fled the house with their children. What's the special circumstances that she could claim? Okay. Anybody else? Yep. Adequate provocation, because she could say she was so upset for threatening to take her child. That's a situation that would happen in reality. Mary and John, this is the last one I'm going to do for this one, have been married for 15 years. Mary discovers that John has been having an affair for the past year. They both argue and sleep in separate beds that night. In the middle of the night, still very upset, Mary stabs John once with a knife while he's sleeping. John survives, and Mary tells police she couldn't control herself. Which circumstance would likely be claimed? I think it's lame, but okay. Some say coercion. Okay, I'm going to go with it, but I already know what it's going to say. I know what it's going to say. That's not right, because she wasn't coerced into it. Not quite adequate provocation would likely be claimed in this case, because Mary was upset with John, and she just kept playing it over and over and over. So it wasn't coercion. So you got to be careful and watch those special circumstances. All right, let's go to the next section. You can do the rest of these yourself. Okay, now let's look at homicide classifications. You should really be up on this, because I spent a lot of time talking about this. I did tons and tons and tons of these kinds of cases. Okay, Frank has a long-standing hatred for Kim. Frank purchased a handgun and hid in the bushes outside Kim's apartment when Kim, okay, be careful about jumping too fast. But when Kim exited, he shot her. But yeah, this is, you know what, when you take these tests, make sure you look and says, nah, it wouldn't be voluntary manslaughter. It wouldn't be involuntary manslaughter, because it showed that there was a plan and a forethought. So this is an easy first degree. So you guys correct. All right. He in other words, he laid in the bushes, literally, as we use the term. John is a gang member who's involved in ongoing battle for drug sales turf. John tells his other gang member that he's going to kill Jose. John leaves armed with the firing gun and kills Jose. What's the crime? And why? What did him in? As I told one of my clients once, what did him in? Yeah, yeah. I said to my client, "You talk too much." That was right. Yeah, yep, and that's correct. Yep, first-degree murder. Last one. Excuse me. Jackson and two of his friends hanging out on the top floor of a parking ramp. Jackson, who has a violent history, targets another man, Rick, and tells his friends, "Watch this, I'm going to kill that guy." Jackson punches Rick in the face, picks him up, and throws Rick over the ledge. Come on. This is a simple one. Yeah. Yeah. Again. Yeah. They made this one. They made these little easy. One last one. Mike is drag racing against Matt, a highly populated entertainment in a district. Mike drives through a red light at a high rate of speed and collides with another motorist, killing the driver. What homicide classification would this be? Involuntary. Anybody want to go for first degree murder? Anybody want to go for first degree murder? Anybody want to go for involuntary? I suckered you in by saying that. Which one do you think? A or B? Some say A, some say B. Okay. Not voluntary. Involuntary manslaughter is correct. So those of you who had involuntary manslaughter, which was A, because Mike didn't display any premeditation. That's why it couldn't be murder. But his reckless action caused the death. And then you can see the key terms activity in this module to review the homicide classifications again. And the last one I'll do in this section, Robert and David have been drinking. Robert shows off his .44 caliber revolver to David. Robert removes 5 bullets but leaves 1 in the cylinder. Robert spins the cylinder and says to David, "Let's play Russian roulette." Robert points the gun at David's head, pulls the trigger, and shoots David in the head, killing him. What homicide classification? Some say voluntary. Some say first degree murder. Dag, you're a tough prosecutor. Okay, I'm gonna go with this one, but I already know what it's gonna say. No, I knew it wasn't, because involuntary manslaughter is correct. Carol would throw the book at you. Okay, so when Carol runs for prosecutor, you guys remember, she's she throw the book at you. But involuntary manslaughter, or the correct answer, because Robert, he didn't display premeditation or intent, but he was reckless in the use of the firearms. Okay, and so that's that. So you want to study those very carefully. The last one, and I know we're going a little longer, but I think it's worth it, because especially since you got a quiz coming up imminently, to see, I'm seeing how you guys are responding to this freshly bit of information that you just received with this lecture. So let's start this activity. This is the quiz. This is the kind of stuff you're likely to see this week on you do the quiz. The intent to cause death with premeditation is considered what type of murder? Yep. Excuse me, that's correct. A father comes home to find his daughter's 17-year-old boyfriend, of whom he doesn't approve, about to have sexual intercourse with his 17-year-old daughter. Outraged and out of control, the father kills the boyfriend. The father is likely to claim Which one? A, B, C. Okay, why not coercion? Because he wasn't coerced. Why not involuntary manslaughter? Because it was in the heat of passion. And unnecessary defensive force is out the window. Yeah, this is it. Example of adequate provocation in light of circumstances. He lost control. I feel him on that one. Yeah, I'd be guilty of that one. And then the last one I'm going to do. John, 18 years old, and Jack, 19 years old, decided to drag race on a busy roadway and entertainment district. During the illegal act of racing, John drove through a red light at a high rate of speed and killed another motorist. The most likely criminal charge that John will face is what? Yep, involuntary manslaughter. And so that's the worst that he would deal with. So those are the kinds of scenarios that you're going to run across in terms of dealing with this. So any questions about anything tonight before I give you your key phrase? Any ideas about what the key phrase is? Yes. Oh yeah, that's that. Yeah, yeah, that's true. Um, Carol, you think that's the key phrase? First degree murder? Okay. Anybody else? Okay, I've kept you long enough. Murder. That's it. I don't have to worry about degrees. Murder. That's it. Give me that, and you got your points. Okay, thank you guys for coming out again. I really appreciate you guys coming out. This makes me feel good when I see um, you guys. Thank you, Carol. Hope you got yourself all situated there. And that's all I'm gonna say about that. So, okay. All right, everybody. I'll see you guys next week. Adam, Carol, Chris, Gress, Junior. I remembered, right? Junior, am I right? Yes. The answer to your question, did you miss some of the lecture? Yeah, but don't worry about it. You came in at 7:20. Yeah, yeah, you missed a whole lot. Of course, though, time zone differences. We started at 8:30 Central, so which could be difference whether you're east or west. And I know the answer to that, but I'm not going to put it out there. But you know what I'm talking about. So, yep, you can go back and listen to the recording. That's the beautiful part about it. Well, you guys, again, good night. I got some grading to do tonight. I enjoy hanging out with you guys, and thank you again for spending this time with me. And I'll see you next week for week 4. Remember, study hard. Get practice quizzes. Remember, go back and do the ones for week 1, week 2, and week 3. That's how you get ready for that. That's just a little tip. I'm just saying, those who follow what I said will get the best grades. I guarantee you. All right. Good night.